The following program is made possible in part by the Dayton Bar Association.
Welcome to You and the Law. I'm Mike Monta, your producer and host for tonight's program, and this is our first show of 2018. Our topic tonight is going to be bankruptcy and debt relief and anything to do with that. Joining me as expert guests on our program tonight from the United States Bankruptcy Court, Mr. Jeffery M. Kellner, a bankruptcy trustee, and a bankruptcy attorney of some note, who's been on our show several times, and an old friend of ours, Mr. Richard E. West. Before we get to our discussion tonight, let me remind you that You and the Law is a monthly presentation produced here at the studios of the Dayton Access Television. Dayton DATV is on Channel 5 and part of the Spectrum Cable Network here in Dayton. Program's also cable cast north and south on Channel 6. If you're watching on Channel 6, don't change the station. And we come on tape delay through the auspices of the Miami Valley Cable Council. We also stream live at datv.org. And the executive producer for the program is former domestic relations judge. I was trying to think of what branch he was in, Judge Mike Brigner. This is an audience participation program. We are coming to you live, and periodically you'll see a number which should be on the screen, 223-5311, and you can call in and ask our expert guests questions about bankruptcy and credit and debt relief. So we're also sponsored, as you heard at the top of the show, by the Dayton Bar Association since 1883. Not this show since 1883, but they've been in history since then. So let me turn to our guests and ask them to tell you and introduce themselves a little bit more about their backgrounds and familiarity with tonight's topic. And I'll start first with Mr. Jeffery Kellner. Jeff, good to see you.
Well, thanks for letting me be here today. I always like to talk bankruptcy. My name is Jeff Kellner. I am a Chapter 13 trustee. I'm not with the court. I'm an independent contractor for the Department of Justice, and we administer 13 cases. And then we report to the court, but when we go in front of a judge, we are just a party just like Rick here. So we have about 4,500 cases at all times, and what we do is we administer the case all the way through, collect the money from the debtors, and pay their old debts and sometimes their ongoing mortgages.
Okay, thank you. Good to have you. And turning to Rick West. Good evening, Rick.
Good evening, Mike. It's good to be here again.
And about yourself a little bit. What do you do in the bankruptcy field? What's your background?
Well, I am a board-certified consumer bankruptcy specialist. I've been practicing bankruptcy law here in the Dayton area since 1986. I've had the pleasure and privilege of representing probably over 20,000 families, helping them to reorganize their finances, wipe out debt, and rebuild their credit. Got offices in Cincinnati, Dayton, Huber Heights, and now Columbus. Okay,
good to have you here. Okay, let's start out by talking a little bit about what bankruptcy is and what are the options, how do we get there, who can file, and what does the court do, things like that. So Rick, we'll start with you. What does your practice consist of?
Generally, when someone is facing more debt than they can handle, they're looking for different options. There's an awful lot of information on the internet, debt management programs, commercials on TV. It seems like everywhere you look, there's somebody trying to tell you, somebody trying to sell you some sort of a program to help you with your debt. The one that a lot of people will look at last, but probably should look at first, is bankruptcy. Now, if a family comes to me and they've got more bills than they can handle, we're going to go through all of these different options. If they don't qualify or what doesn't make sense as a non-bankruptcy option, then we're looking at Chapter 7 and 13. Most consumers are eligible for one or the other, or maybe both. And that's going to wipe out all or part of their debts, reorganize their finances, and bring their expenses into line with their budget so they can go forward and start rebuilding their credit. People think, in many cases, incorrectly, that filing a bankruptcy is a long-term detriment to their credit, but that's not true if it's handled properly. And so as a consumer credit counselor, I have programs to help my clients recover quickly. Bankruptcy is here to help the common consumer recover from, a lot of times, things that weren't their fault. Things beyond their control got them behind the 8 ball. Bankruptcy is a way out.
All right, so what's the threshold? When should a person start thinking, maybe I need to do something about my debt? Am I going under? Can I pay all these bills? Can I stop people from filing suits against me?
A good test would be to honestly sit down and take a look at the finances. Most people that I counsel have never made a written budget, and that is where we want to start. List your income, list your expenses. If you don't think within a year to 2 to 3 years, based upon the income and expenses that you have, that you're going to be able to significantly reduce your debt, that's when you better talk to someone who can help you out.
Okay. Now, Jeff, you're Chapter 13 trustee. Tell us a little bit about what you are looking over and what you're administering within the Chapter 13, and what kind of debts do you see and can be discharged? And I'm asking a lot of questions in one thing.
And you could be a business case in a Chapter 13.
Okay.
We just don't see very many of them, and it had to be a small business because of the debt limits. Our job is to look at a Chapter 13 when it's filed. We run the numbers, we check them out, we kind of use some certain standards by the IRS, and we then examine the debtors at a 341 meeting of creditors. And they're under oath, and the attorney comes in, and we ask them questions about their debts and their assets. We make sure everything is honest to the best that we can, and we just follow up with the questions. We make sure the plan works over 3 to 5 years, because most debtors are in between 3 and 5 years, depending on their income and what they call the means test. But our job then is to kind of report to the court if we believe the case is in compliance with the bankruptcy code.
Okay, let's distinguish. We've talked about some terms, Chapter 7, Chapter 13. Let's distinguish between them, what they are and what they do.
Chapter 7 is not a payment plan. It's where the unsecured debt, generally credit cards, medical bills, personal loans, payday loans, those kinds of debts are discharged, which means legally erased, with no payment whatsoever. Most people will qualify for a 7 if their income for their family size is below a preset threshold. That's what the means test is all about.
All right. What would that be?
For a family size of 4, it's about $83,000, more or less, and that number is adjusted. So if a family makes that much or less, family size of 4, then they probably are going to qualify for a Chapter 7. Now, Chapter 13s are payment plans, but that really is not the whole story, because a payment plan in Chapter 13 might pay as little as 1% of the unsecured debt. Now think about this. If a Chapter 7 is a 0% payment plan, How different is that plan from a Chapter 13 plan that pays back 1%? So Chapter 13 is a payment plan, but it could be a payment plan that pays very low percentage. Chapter 13s have many advantages compared to Chapter 7, and so when people think of Chapter 13 as a payment plan that pays back all their debts over time, that's really not accurate. And Jeff can tell you that most of the payment plans that he'll see, they don't pay more than a couple cents on the dollar.
Okay, let me interrupt you just for a second. Our floor director tells us we have a call coming in, so we'll take that call right now. Good evening, you're on You and the Law. Okay. Oh, they're there, maybe. Good evening. No, they hung up. Okay. Well, if you're watching and you'd like to talk to us, 223-5311, stay on the line, and we will get to your question. Okay, we're going to go over to Mr. Kellner here. He's going to comment on Rick's.
A lot depends on what they're trying to accomplish in the bankruptcy.
Okay.
If they have a lot of unsecured debts, not a whole lot of assets, Rick might say you might be better off in a Chapter 7. If you're trying to save a house, you get behind in the house, you have a rearage, the bank starts talking about foreclosing, you almost have to go into a 13 to save a house, because you really can't do that in a Chapter 7. So a lot depends on the circumstances of the debtor that Rick's going to be looking at and trying to figure out which is the best chapter to go in.
Okay, our caller's back,
Okay.
I think. Good evening, you're on You and the Law.
Hi, I have a question for Mr. West.
All right.
If I declare bankruptcy, can I lose my house or my car?
Okay, the question I believe was, if I take bankruptcy, will I lose my house and car? Or car. Did I get that right, caller?
Yes, if I declare bankruptcy, could I lose my house or my car?
Okay, and we've just generally been talking about that, so go ahead, Ray.
And that's probably one of the first questions that most people are going to ask when they consider bankruptcy, because they've heard all these horror stories about losing houses and cars. In fact, if they look it up on the internet, they see Chapter 7 referred to as a liquidation bankruptcy, where all of the debtors' non-exempt assets are liquidated for the benefit of creditors, but that almost never happens. There are laws called exemption laws in Ohio that protect our ownership in our property, the equity in property, so that almost never are you going to see somebody lose a house or a car in a Chapter 7 because of the amount of equity ownership they have. Now, that being said, in a Chapter 7, they need to be current on their payments, and that leads back to what Mr. Kellner was saying, is if you're behind on your house and you're in foreclosure, a Chapter 7 is not going to keep that house from being lost to foreclosure. You'll need a Chapter 13 to do that. But just because you file a bankruptcy, no, you're not going to lose your house or your car necessarily.
All right.
Great, thank you so much.
Okay, you're welcome. Okay, now we also talked about secured debts and unsecured debts, so why don't we talk a little bit about, it's probably self-evident, but maybe not. Secured debts maybe not being dischargeable in most circumstances, and unsecured debts are. Yes? No?
About half and half.
Okay, go ahead.
A house is a secured debt, secured
Right.
collateralized by the mortgage. And what happens in a 13 is we will catch up to mortgage arrearage. We'll pay the ongoing mortgage. So when they get out of Chapter 13, in 3 to 5 years, they will be current on their payments.
Now, when you say we will pay that, who is the we here?
The debtors.
Okay, you're
the debtors
not
pay us, we
Okay.
pay the mortgage
Okay,
companies.
all right.
But they will be current on their mortgage. So
Okay.
they get to start over again.
Okay.
Most cars, at least in a 13, are going to be paid for to the value of the car. So when they emerge from Chapter 13, the cars will also be paid off.
Okay.
Taxes will be current. The priority taxes will be paid, have to be paid. Unsecured taxes will be discharged out, and the unsecured portion a percentage of it will be paid and the balance discharged out. So it all depends on a lot of facts, what they want to keep, what they can afford to keep, and that's what Rick does with his clients.
Okay. Now, you were talking about the Chapter 7. Do more people want to just discharge their debt and start over, or do they want to try and reorganize through a Chapter 13, or do they not have any choice?
Oftentimes there is a choice.
Okay.
I think many people come in to see me with an idea that it's better to file a Chapter 7. The reason for that is they think a no payment plan is better than a payment plan.
Why do they think that?
Well, a lot of it is psychological.
Okay.
A lot of times people feel that, you know, by golly, if I've got to file a bankruptcy, and and that's like the biggest negative that they can imagine, then if they have to swallow that bitter pill, then they want to walk away with no payments because that's what's best for
A
them.
really clean start.
Right.
Okay.
But that is not always what's really best for them. And let me give you a real simple example. Most of us are going to have a car payment most of the time. Very seldom are you going to have a car paid off for long anyway. If someone comes to me with a car that is more than a couple of years old, 2.5 years old, and they have over mortgaged the car, let's say they owe 10 grand on this car and it's only worth about 5. And I see this every day. In a Chapter 7, they can discharge all of their unsecured debt, their medical bills, credit cards, personal loans, payday loans, with no payment at all, but they're going to have to pay $10,000 for that car because that's the agreement. You can't modify it in a Chapter 7 under most circumstances. But if I take that same car and I put it into a Chapter 13, I can pay what the car is worth, and that's what Mr. Kellner was saying. They're paid out to what the car is, the value of the car
That
is.
seems like a real deal, doesn't it?
It is an incredible deal.
Yeah.
There's more though,
Okay.
because imagine this car loan's got an interest rate of say 20%. If I take that car into a Chapter 13, I'm only going to pay $5,000, and I'm going to pay that at about 6% interest. So I just cut their car payment in half. They're keeping the same car that they drove in to see me in, and I'm wiping out all of their other debt at the 1% level. Not 0 in a Chapter 7, but 1% is pretty close. And so that's why, even though somebody may come in to see me thinking a Chapter 7's in their best interest, a Chapter 13 will do a better job for them.
Let me ask you one question which you've both alluded to a couple of times. This 1% thing. I'm sure our viewers are interested in what you're talking about there.
Well, the percentage is how much of your unsecured debt gets paid in the plan.
Okay.
And it can go from 1 to 100.
Right.
Many of them are low, and I'm sure Jeff would tell you that a lot of them are just a couple cents on the dollar.
Right. Okay. So somebody comes in and they talk to you, you would discuss these differences with them then, rather than taking their opinion of what they heard on the internet or saw on the internet. Not that the internet's wrong, I guess, but yes, no.
Of course.
Okay.
And on the internet too, a lot of times people, Mike, will come in to see me and it's clear to me they've done their internet research. And I think that's good. A lot of times they get a good basic background understanding of what their options are before they come to see me. Sometimes they get it wrong because some of the stuff is complicated and they don't understand it right, or its application is not something they understand. But I always joke with them and say, look, I go to WebMD before I see my doc, but I go to my doc and I listen to my doctor when I make these important decisions.
Yeah. Okay.
And the thing you really got to realize is, like in Chapter 13, it's a lot of math. It's really just all math, and you have to sit down and figure out your value of your assets, your debts, how much income you're making, how many years you're going to be in it, and then figure out what you can afford.
Okay.
But the software programs just use a lot of math.
Okay.
Software.
Let's take a short break. We don't have any commercials on You and the Law, but we do talk about our sponsor, who is the Dayton Bar Association, and as I told you earlier, has been in existence since 1883, when Chester A. Arthur was the President of the United States. and we didn't have the internet back then, so if you needed credit counseling, you'd have to go out and find Rick West's great-grandfather, if he existed at that time. Did they have bankruptcy in 1883? When did that come into existence?
Came in, what, 1899?
Yeah, back in the
Difference.
1800s. People don't realize how long bankruptcy has been a part of American jurisprudence since the 1800s. Abraham Lincoln was a bankruptcy lawyer. Thomas
Okay.
Jefferson needed a form of bankruptcy. It didn't exist in the same way as it does now, but many of our founding fathers were no stranger to debt relief and the need to adjust our finances.
Very interesting. Okay, let me talk a little bit more about the Bar Association here. Many services for the community, and it is at daybar.org. We have a lawyer referral service in which, if you don't have a lawyer, you could call them and they would refer you to somebody who specializes in the field that you are interested in. And that number is 222-6102. There is a notary public service. If you are interested in becoming a notary for whatever reason, businesses or working for somebody who needs one, there you can become a notary through their application and testing service. One of our best programs is the Wills for Heroes, where volunteer members create wills for emergency first responders, police, and EMTs. If you think you qualify for that, and it's very worthwhile. If you don't have a will, you and your family, they can help you. It's once a month on a Saturday usually. They can tell you the time and place. We also have speakers bureaus, public service committees, and Sally Dunker is the new director there and doing a fine job, and hope to have her around for a long time. Bill Wheeler just retired. If you knew Bill, you knew how good a job he did also. So you're watching You and the Law. We're talking about bankruptcy, credit, debt, things like that, and we have Mr. Rick West, who is a noted, is that a good term, noted bankruptcy attorney, famous bankruptcy attorney? How does that sound?
Well,
what would you like?
I'm proud to serve, and you can call me whatever you like.
As my granddaughter says, anything but late for dinner?
Absolutely.
Okay, but anyway, all kidding aside, Rick has been very helpful in this field in the community for as long as he said he was, back in the 80s, right?
Over 30 years.
Yeah. And of course we have Mr. Jeffery Kellner, who is the Chapter 13 trustee here in Dayton, Ohio, in the federal court system. So again, 223-5311. If you want to call in, it's audience participation. We're coming to you live and in color. So remember when they used to say that? They'd have a peacock. Why don't we have a peacock on the show here? I don't know. They don't know. Okay. So before my commercial, we were talking about the differences between Chapter 7 and Chapter 13. And let's talk a little bit about the requirements for Chapter 13 and what it does and how that's administered.
The requirements for 13
Wait
is,
a minute.
you got a call?
We're going to have a call. Hold that thought, though. Good evening. You're on You and the Law.
Oh, I'm a student calling to see if I can get some of my student loan debt.
Move back from your phone just a little bit. We can't hear you. Or move back from your television set, I mean. You still with us? Okay. Go ahead.
Hi, I'm a student. Calling to see if there's any way I could refinance my student loan debt.
Okay, I'm assuming you have a student loan debt.
Yes.
Okay, well, we can answer that for you.
Jeff's the
Jeff?
student loan guy.
There are a number of companies out there that will refinance, and you see them on TV all the time now. The government, which the majority of student loans go through the government-backed student loans, will often consolidate, refinance, and will work with people with student loan debt. Sometimes the student loan debt is so much that people consider bankruptcy. And Rick and I have talked about it, and we talked about it earlier. You know, can bankruptcy help somebody with student loans? And the answer is maybe. It's been tough because student loans are non-dischargeable. And again, many people refinance, many people defer them for years. With the interest and collection charges, I've seen student loans double in 10, 15 years just because of that.
Okay.
So it's tough to just let them go on forever. You almost have to deal with them at some point.
Okay, so what do we do?
There are a number of programs offered by, at least for federal-backed student loans.
Okay, well let me ask it this way. Somebody gets into bankruptcy, they're, I guess, you know, if they came to Rick, he would say, well, you can't discharge this. We can do a Chapter 13. What would the plan be for that? Or option, let's say option.
The majority of plans right now is the student loans come in as a general unsecured debt. They are deferred from collection for 3 to 5 years.
Okay.
Interest is still charged, and when they get out, they will have to deal with that student loan. They get a reprieve from it. They get rid of all the other debts. So when they get out, again, they have a little bit more bargaining power, a little bit more money to set up a payment plan. One other option that we are exploring is for the debtors to enter into an IDR, an income-driven repayment plan that kind of looks at their income and expenses on a yearly basis and determines how much they have to pay onto that student loan, and they have to pay it, reapply and pay it for, say, 20 years. And what we're trying to do is explore avenues where that IDR is being paid through the Chapter 13 plan, so when they get out, they will not be in worse shape than when they went in.
Okay, so you can get rid of it, but you can make it a little less painful.
We're working on a solution that might get rid of part of it, or at least continue paying on it while you're in the 13.
Okay, and a solution through what, legislation or?
Right now, the programs are out there. It's just working with the, people like Rick, the debtor counsel, and the court system judges, and trying to come up with an agreed order then that provides for that.
Okay, Rick, any comment on this?
Well, the student loans are a problem, and because they're not discharged in most cases, what we often see is essentially a sequencing of debt. And what I mean by that is, unless, as Jeff said, you enter into this IDR while you're in a bankruptcy, which is something you can do sometimes, your bankruptcy is going to place your student loans into a state of administrative forbearance. What that means is you would not make payments on your chapter, or your student loans rather, while you're in your bankruptcy. Yet they're not discharged. They're waiting for you at the end. So while you're in your bankruptcy, you're wiping out everything else that's dischargeable. So when you get out, those monthly payments are gone. Those debts are discharged. But then the student loan kicks in and you begin to pay that. So if you imagine a payment plan, maybe this is your Chapter 13 payment plan, it's wiping out all of your other debt, paying off your cars, you get to the end, now you've got some money in your budget to start working on your student loans. So that's an effective approach that we've been using for a long time.
All right.
And if you own your student loans, the government can come after you through your tax returns. They can come after your income. And some people will file bankruptcy just to get a reprieve for a few years.
Sure.
Okay. Caller, does that address your question?
Yes, sir, it does.
Do you have any follow-up?
No, thank you.
All right, thank you for calling.
Thank you.
All right. Okay, well, I think we worked through a little of the Chapter 13 there through that question. As we've talked through the program, unlike a Chapter 7, the Chapter 13 requires some planning and, as you said, some math and arithmetic. So who draws up this plan? Is there a model for it, a format, or the debtor and their attorney, or if they're doing pro se by themselves, responsible for doing that?
Go ahead on that one.
Well,
Or is that too much?
no, that's
Okay.
a great question, because to get the best plan requires an awful lot of thought and experience in doing Chapter 13 work. And the best example that comes to mind is someone comes to me. They have been experiencing financial difficulties for some time. In fact, it generally takes 6 to 12 months of thinking about coming to see me before someone actually makes the appointment. So they come in and they've got this old car and other things in their financial life that suggest to me that a Chapter 13 is going to serve them best. That's going to be their best tool. But I'm looking at this person with the old car and I'm thinking to myself, this car is not going to last for 5 years.
Mm-hmm.
Now, if I wasn't thinking about it and I just plug all this information into the formula, I'm going to get a Chapter 13 plan that will be acceptable to the court and it will be approved by the trustee, and so off we go. But I know that during this 5-year plan, that car is going to die. So I'm going to tell my client, look, you need to get another car. So part of the plan, my plan, is going to be to set this client up for a successful outcome in his Chapter 13, and many times that means we're going to replace a car so he has reliable transportation that will last while this plan is going on and not a bomb that's going to explode in the middle of it. The reason that this is important is because you have to be able to see more than just the person's now. You've got to be able to predict what's going to happen in the future. Sometimes that means taking into consideration a health issue. Sometimes that means taking into consideration what's going to happen with their kids. Sometimes they have changes in their income due to retirement plan changes. Sometimes they retire in the middle of the plan. You can actually forecast these things. There's so much that goes into a well-crafted Chapter 13 that I can't imagine someone wanting to go to a general practitioner, someone who doesn't do this stuff regularly, because there's just so many benefits that a person can get out of a Chapter 13 if enough thought is put into its construction.
Well, you've got to have a job. I don't think we've...
You're supposed to have income.
A source of, a
Income.
legitimate source of income.
Yes.
Is that right, or legal or something like that? Not having illegal people shy away from us, I guess, but you would determine before filing this if their source of income would meet the requirements that the magistrate would accept, correct?
Right. The code requires regular income. Now, that regular income can come from a couple of different sources, and it can even come from unemployment, it can come from retirement, it can come from Social Security, or even family assistance. So long as it's regular, it meets the test. So there are creative ways to satisfy that requirement of the law, Mike, that you can get a Chapter 13 approved, even if it looks on its face that maybe this thing is going to be kind of shaky. If you've got family support, that might be all you need to come out with an approved plan.
Suppose they've got everything else going for them, except for they don't have this source of income that you're talking about. Are they going to automatically be out of planning, or do they have to be creative at some point?
Well, I think definitely they have to be creative. The feasibility, though, is a problem. If there's no income and their schedules I and J, which is income and deductions, expenses, it has to be a positive number, or else we aren't even going to recommend that to the court.
The income's got to exceed what they want to pay and their expenses and things like that.
Some people might have a super low budget just to get to that point, but they might say their church helps them, their friends help them, they have a second job, they're going to work more overtime. And we tend to be very lenient on feasibility issues. Our view is give them a chance.
Is there oversight on these plans? Like Rick does a plan with his client, gives it to you, you say this is fine. How does it become administered, or do you just wait for the 3 or 5 years to go by?
We monitor the payments coming in, and if there's any
the payments
problem,
come to the trustee. Okay.
Yep. And then we also get their tax returns every year, and we kind of look at that and see if something big has changed. And if their income went up $100,000, we're going to sit down and talk to Rick. And it might not be that, it fairly seldom is, but we will look at their tax returns and kind of see if something has changed.
Can the plans be modified midstream?
Yes, and we see that happen a lot.
Okay.
Things 5 years is a long time for debtors. And
To go by the same plan.
income.
Even if you didn't have a plan, everything isn't going to be exactly the same. Okay. We've got a little bit more than 20 minutes to go in the program. You're watching You and the Law. We're talking about bankruptcy, debt relief, things of that nature. We've got Mr. Rick West, attorney at law in the bankruptcy field, and we've got Mr. Jeffery Kellner, who is the Chapter 13 bankruptcy trustee here in the Dayton area. We are coming to you live and in color. And our number for calling in, this is an audience participation. We want you to participate, you the audience. Anything you want to find out about bankruptcy, whether you should have one, what you should do with if you get in one. And there's our number right on the screen right below me, 223-5311. Call in, and if anybody can answer your questions, our guests can. So, back to the show. There's some myths, I think, about bankruptcy. We talked about this before, and one of them was not the internet before, say, 10 years ago. But what are some of these things that you would like to dispel for folks tuning in that said, well, I better not take a bankruptcy because this bad will happen to me? And what are the benefits of ignoring those myths?
The number one myth that I see and have always seen in the 30-plus years I've done this is that bankruptcy is going to ruin a person's credit for a long time. I've had people come in, Mike, and tell me, well, I know I have to file, Mr. West, but I know I'll never have a house again. I'll never be able to buy a car. I'll have to live a cash life. And nothing could be further from the truth. Not only further from the truth, it's the wrong approach after a bankruptcy. One of the things that I offer my clients as a certified credit counselor is a program to help them rebuild their credit quickly after filing a bankruptcy to discharge their debt. If you follow a certain program and you take certain steps and you do it the right way, it's possible to recover credit quickly after bankruptcy. My clients typically end up with credit scores of 650 or better only 1 year after their discharge. People delay coming to see me for financial advice for years because they're afraid that it's going to kill their credit, and they want to be able to have all the things that credit means, a nice car, a house or something. And it's sad because that's just not true. Years ago, it was a lot more difficult to rebuild credit after bankruptcy, and I think that's where the origin of this myth lies. Most myths have some kernel of truth in their origin at least, and I think that's what's happening here. But if people knew the truth, they would get better advised and probably be looking at considering bankruptcy options a lot sooner than they do now in many cases.
If they're in a position that they have to file bankruptcy, their credit scores are going to be pretty bad anyhow.
Mm-hmm.
Because they're going to be in debt, they're going to be delinquent. They're going to be in trouble. At least 7 and even 13 is a good way to start rebuilding it. It gets rid of the debt, it'll get them discharged, and then, like Rick said, he can help them start rebuilding. People buy houses, people buy cars while they're in Chapter 13.
Mm-hmm.
So it can be done.
You talked about credit scores, and of course this is, I think, a newer phenomenon in the media. Do you do assessments of credit scores within the bankruptcy at all, or is it not part of it? I know if you're buying a house or something, somebody attaches a credit score to you as far as how many points they're going to charge you or whatever. Is it something you implement, or is it basically unnecessary? As Jeff said, your score is pretty low anyway, probably.
From our side, we do not look at credit scores.
Mm-hmm.
it's just not part of the factor and what the real circumstances are.
It's not part of a qualification for bankruptcy, and it's not part of bankruptcy law, and that's why I've found that most of my colleagues who practice bankruptcy law do not address it at all.
Do you address it? You talked about being a certified credit counselor. Did I get that right?
Yes.
Okay. Do you assess it in that then?
I do. I think that in order to provide a full financial recovery for my clients, I want to address their debt, of course, and oftentimes bankruptcy is the best tool to do that. But there's also a program to rebuild credit, and I also want to teach them things that oftentimes they don't know about their credit score. I have had lots of clients, Mike, come in to see me with credit scores over 700. Their payment record is perfect, but they've been doing it by robbing Peter to pay Paul and borrowing from family and robbing their retirement. And so it is not uncommon for me to see someone coming into my office with a perfect payment record and a 700 plus credit score. Now it's a house of cards, not going to be able to sustain it, but I see it all the time. And the reason people do it is to maintain that credit score. When I explain to them, yeah, your bankruptcy is going to cause your score to go down, but we can get it right back up there in a relatively short period of time, it's like a new revelation to them, and they are then more willing to look at the option that really they need to look at, the bankruptcy option, but they were afraid to because they thought it would be a permanent end to their credit.
Part of what we do is we try to make sure that their lifestyle that got them into a bankruptcy will change over that 3 to 5 year period. There's a set budget, they have to stick to it. And we're, at the beginning, we kind of review, are they keeping this $50,000 car? More than likely not. Do they have a whole lot of toys, the boats, the ATVs and everything else. So some things have to go, some things in a bankruptcy just will not be allowed.
You all have been doing this for a long, long time, and you've probably seen some trends in your time also. Do you feel as though what brings people into bankruptcy is more living a style that's too high, or maybe they have emergencies that send them over the cliff, I guess?
Part of my job is to find out if there's fraud or anything else out there. The vast majority of people are good debtors.
Okay. Fuller Director tells me I have a call. We're going to take that call. Good evening. You're on You and the Law.
Hello?
Yeah, move away from your TV a little bit.
Okay.
Okay. What's your question?
Well, I wanted to know how I can figure out which bankruptcy chapter to follow. I know I think there were 2 different ones.
Yes, Chapter 713, and you want to know how to decide which one?
Can I just, well, obviously I'd rather just wipe out all of my debt, but is there some sort of rule you have to follow? Or I think everybody should be filed chapter 7.
Okay. I think the question is, do I have to file Chapter 7? And do you have to fall into a certain group to be in one or the other? And we've been kind of talking about a lot of this, but that's a little bit different twist. Not a twist, I mean a different viewpoint. Is that correct, caller?
No, what I'm trying to find out is, okay, I have a lot of debt, I want to file bankruptcy, but what, I don't know what the word is that I'm looking for. What determines which bankruptcy I have to file, I guess, is what I'm asking.
Okay.
So if I understand the questions, what determines whether you file a Chapter 7 or 13? Is that the question?
Correct.
Okay. There is a means test that you go to start that question. So if your income is below a certain threshold, and for a family size of 4, it's about $83,000. So if your gross, and that's not take home, that's gross. If your gross income is under that, then you're probably going to qualify for a Chapter 7. but you would also probably qualify for a Chapter 13. So in that sense, you could do either one, and the right one would be dependent upon what your personal circumstances are and what you're trying to accomplish. Now, if your income is above the median, you probably are not going to qualify for a Chapter 7. That's not necessarily the case, but you probably won't, and you would be looking at only being able to file a Chapter 13. But as I've explained earlier in the show, a Chapter 13 might pay as little as 1% back to your credit cards and medical bills. So it would be, I like to say, it's the functional equivalent of a Chapter 7. Now, if your income is well below the median, a lot less than the average, and you might find that you can't afford to be in a Chapter 13. So I sometimes see sad cases where the income due to medical disability or loss of job has now gone so low that you can't afford to keep the house. So even though Chapter 13s are good tools to keep the house, if you can't afford it, then that option won't be available to you. Maybe the best you can do is file a Chapter 7 and wipe out the mortgage debt and start over with the lower income. So does that help?
Yeah, it does. Thank you for your
You're breaking up. What was your last comment?
I thank you very much for your.
Oh, you're thanking us? Oh, okay. Well, you're welcome. Thank you for calling.
Have a good night. Bye-bye.
Good night.
And what's hard to do is to tell somebody, you really need to give up this house or surrender the house. You know, people don't like to do that. Sometimes they just can't afford that house.
Yeah.
And that's hard, you know, sometimes they don't want to listen to you or me when we tell them, you know, you're so far in the water, think about surrendering it.
We have another call. It's on line 1, so we're going to take that call. Good evening. You're on You and the Law.
Hi, thank you so much for taking my call. My question is a hypothetical one. Say, hypothetically speaking, that I'm married and that my spouse is very bad with money and racks up a lot of debt. What I want to know is it possible for my spouse to file for bankruptcy separately from me and it not affect me, or am I sort of on the hook for that, or how does that work?
Okay.
We'll take the hypothetical answer off.
Okay.
Thank you.
I think the question basically is, if one person takes a bankruptcy, does the whole family have to take one? So
I see that regularly, and the answer is the law does not require a spouse to file with a spouse. So I can be married and file my own bankruptcy and not involve my spouse. It wouldn't impair my spouse's credit. My spouse would not be involved. I don't need my spouse's consent, permission, or cooperation. My ability to file a bankruptcy is not affected by my marital status, in other words. Now, that being said, the qualifications for eligibility to file bankruptcy might involve the household income, and my spouse's income would be part of that, but also I would be able to deduct from that spouse's income the separate debts that my spouse would have. So it's a little more complicated when you have a married couple that wants to file one and not the other, but we do it all the time, and there's no legal impediment to doing that.
The problem is if they have joint debt.
and
that makes
joint
it a little
assets,
more,
right?
And that makes it a little bit more difficult.
Yeah.
It can happen, it just gets a little bit more
Okay.
complicated.
It's got to be separate debt, though, right? Isn't that what we're talking about?
Doesn't
To
have to
file
be.
separately? No?
No,
Okay.
but the problem that you run into is, say, husband and wife have a joint car debt. Husband files bankruptcy. His legal obligation is gone, but the wife's is not. So now she's stuck with the whole thing. You see this when you've got parties who separate, maybe they're contemplating a divorce, maybe not, but one of them has decided to file bankruptcy. That spouse, the filing spouse's bankruptcy discharge does not protect the non-filing spouse. So if there's joint debt, the non-filing spouse is now required to pay all of it.
Okay. Does that answer your question? Caller. Okay.
I guess.
We've lost our caller. I think that answered the question. You brought a couple other things we didn't talk about. People go through divorces, and sometimes that hurts them financially. What restrictions do they have about filing to, let's assume they assume debts through a plan or the court order? Can they bankrupt those now?
Well, the big question that would come up before Rick is, do I file bankruptcy first together, or do I get divorced?
Okay.
And that depends on a lot of factors.
Is that too complicated for the last 6 minutes of this show?
No, it's a great question
Yeah.
because it happens all the time.
Right.
You know, people who are contemplating a divorce oftentimes know that the two households separately are going to be a lot more expensive than the one household was
Yeah.
to begin with, and so it takes a perhaps strained to begin with situation and makes it worse. Although every case is different, as a general rule, if the parties are cooperating, communicating, and can speak, to each other, it's a good idea to think about filing a joint bankruptcy. Sometimes they have to have separate attorneys. It depends if they can work together or not. But file a joint bankruptcy in Chapter 7 so that all of this debt is wiped out and they go their separate ways with clean slates. And sometimes that works, and sometimes there's some planning involved in making sure you get the best result. The other thing that happens is sometimes people are in Chapter 13s and they decide to get a divorce. So it starts out as a married joint Chapter 13, and then they divorce. In that case, your Chapter 13 can be affected. It could continue on, and oftentimes does. One party makes the payments and the other one doesn't, but the plan is satisfied. Sometimes one party will split off and then do a Chapter 7. They'll split the 13 into two, and one converts to 7. So, family law issues and bankruptcy issues do intersect a lot, and it takes some thought and experience to get the best result for your clients.
So there's no real easy answer which to do first, right?
The chicken or the egg question.
Okay.
Yeah.
But things like child support, spousal support, those can't be discharged. Am I right on that? I believe that I am.
Those terms, yes, division of property might be a question mark.
Right.
Yeah.
Okay. How do creditors feel about this? You'd think that they'd be unhappy, but I think the reverse is true.
Creditors really have very little input into this bankruptcy process. It is not something that we negotiate with creditors. They get what they get under the law, and they understand that. Oddly enough, and I think this is what you're alluding to, Mike, is when a consumer goes through a bankruptcy case and they don't have any more credit card bills, medical bills, all of their debt is gone, they are deluged with credit offers. Creditors are almost standing in line offering them new credit, looking for an opportunity to take the excess money, the surplus money that's no longer going to pay other creditors' bills, and they want to get in line to be the first to get it. So creditors seemingly react very favorably to bankruptcy filings. New creditors do.
Yeah.
Secured creditors are going to get paid to value. Mortgages are going to get caught up. IRS gets paid. So a lot of the creditors like us to be the payment of bills, and we pay the debts. And so they, like you said, they do favor bankruptcy at times because it solves the problem.
One of the things you said was people have to change their lifestyle, and I think that's why I asked you one of the questions about maybe living over your head. Maybe that's not the right way to put it. Everybody's got the American dream, I think, and wants to do better and better, and they think that they will do better. Unfortunately, sometimes that doesn't happen. So,
Like we said earlier, sometimes they just can't afford that house. And if they're looking, they bought a $500,000 house when banks are giving away money, and they probably should have only bought a $200,000 house. They're going to have to go probably into bankruptcy just to get rid of it. And it avoids being taxed on the forgiveness of that debt.
Okay. Taxes, can you discharge taxes?
You can.
Right.
I've probably discharged hundreds of thousands of dollars of taxes.
Mm-hmm.
If you meet certain tests, then you can discharge taxes in bankruptcy. What a lot of people don't know is even if you're not able to discharge them, bankruptcy often is a great way to pay them, because if I file a Chapter 13, I can pay my tax. A lot of my tax I'm not going to pay any of the penalty on, and the tax payments that I'm making are going to be paid at no interest. Compare that to an IRS payment plan. If you're in a payment plan with the IRS, you have to pay the penalties and you're going to pay interest on the unpaid balance of your taxes. If I take that same tax debt and I put it into one of Jeff's Chapter 13s, there will be no penalties. Well, they'll be treated as an unsecured creditor, probably pennies on the dollar, and there's no interest paid on the tax that I pay to the IRS. The effective result of this is I can probably get out of my tax in half the time at half the cost, Chapter 13 compared to an IRS payment plan. It's very effective to pay taxes in Chapter 13.
Good. We're going to have to leave it there. Our floor director is motioning me that we are running out of time, so I'm going to let you, the viewing audience, know you've been watching a monthly production of You and the Law. We've been talking about bankruptcy today with our expert guests, Jeff Kellner, Chapter 13 trustee for the Dayton, Montgomery County Federal District area. I don't know what you call it. Montgomery, yeah. And Mr. Rick West, a notable bankruptcy attorney in our area. I want to thank all the volunteers behind the scenes who have made this program possible, as usual. And good night to Lily, Katie, and Everett. I've been your producer and host. You've been watching You and the Law. Thanks for joining us. We'll see you next time. Good night.